The EFF leader, Julius Malema, said last week that his party will be working with the family of slain UCT student Uyinene Mrwetyana to file a lawsuit against the South African Post Office and Minister of Communications, Stella Ndabeni-Abrahams, the Post Office employee who confessed to her rape and murder, we're told, had previous criminal convictions. So what does the law say about employing people with a criminal record? To help us understand that, we're joined in studio by labor law expert Craig Berkowitz. Craig, thank you so much for coming through. I really appreciate your time. So there seems to be this idea of being able to sue the post office for the actions of one of their employees. What area of law are we talking here?
Okay, so what we're talking about is the legal concept known as vicarious liability. And what that entails is the employer being held liable for the wrongful acts of its employees. So that's essentially what's being triggered in this particular instance, and that's when the employer becomes liable for the actions of its employees. It's not just as straightforward as that, like anything else in law. There's two components to the test in order to determine whether the employer is in fact liable. You've got the subjective component where you look at whether the employee was furthering his own interests or was furthering the interests of the employer. And you've got the objective test, and that is whether the employee, I beg your pardon, was engaged in the affairs of the employer or not. Now, obviously, the first thing that one would say is there was a criminal act that was perpetrated, and that can never be acting in the interests of the employer. But the question that will be before the court is, was there a sufficiently close enough connection between the actions of the employer or the employee and the business of the employer? So they will be looking at the functions of the employer, the work that the employer does, the work that the employee does, and whether the employee was perhaps enabled or the opportunity was created or the platform was created in order for the employee to have perpetrated the act that he did by virtue of his employment.
So without then conducting this litigation in studio between you and I guess it's significant that this took place inside the post office, and I suppose the time of day that this happened, was it within working hours or after working hours? And also the pretext that, certainly according to the reports, that the victim was basically lured to the post office under the pretext that says, come back a bit later because the machine is not working. All of that gets thrown into the pot somewhere.
That's correct. So I'm also basing it on media reporting. I don't know the facts, and obviously the facts are always decisive in any matter. But based on exactly what you've just summarized, that the platform was created in that he invited the deceased to return to the post office at a later time. Perhaps he was mindful of the fact that he was going to be the only person at the post office, or maybe it was just the way it worked out. But he was very deliberate, it seems, in what he was doing to invite her back at a time when it would be quieter. And as I understand from the reporting, that he then locked her into the post office, and that's where matters proceeded from there.
Do you imagine that this will be significant, Craig, the fact that this employee of the post office was among some 187, if my maths is, if I recall the figures correctly, that were found when vetting was done to have criminal records? And this was not a criminal record for, not paying your speeding fine.
Yes.
It had to do with car hijacking, if I recall the details thereof correctly. And the post office, of course, has its own explanation that, yes, we received this, but it was never flagged with the management and the board, and therefore was never acted upon. And we are in that space now investigating why that wasn't done. But it's a relevant factor, isn't it?
It is a relevant factor, but it's not, I don't believe, going to necessarily be decisive, because there are instances where employers are held liable for actions perpetrated, criminal acts perpetrated by their employees, where those particular employees don't have a criminal record or didn't have a criminal record of any description, but yet the employer was still found to be liable for their actions in perpetrating that crime. So it's setting the bar a little bit too high to say, well, listen, that there was already a criminal record in place, and therefore they're automatically now going to be liable. I would say that more than anything else, it's an aggravating factor. It's not necessarily decisive in
Sure.
applying the test to determine whether the employer is or isn't liable. But certainly it creates a greater difficulty for the employer, given the fact that there was the criminal record in place and seemingly that they overlooked it.
Is there precedent for this kind of case? Are there, and are there enough cases such that, the various advocates and attorneys who are wanting to take this to court with the EFF also supporting them won't struggle to find precedent and draw parallels?
No, they won't struggle. I can just tell you very briefly, just by way of a filler, just to give you some more insight. There were 3 cases that I extracted when looking into this issue, and that was, the first one was where there was a policeman who was on duty, but he wasn't in a uniform, and he went to the home of a married couple, and he asked the husband if the husband knew the whereabouts of the police's wife because he suspected that she was having an affair. An altercation ensued, and the husband was eventually shot by the police officer. The court was of the opinion that there wasn't a sufficiently close enough connection between the actions of the employee and the business of the police. There was a second case where, on this occasion, the policeman was in uniform, he was on duty, and he went to the house of somebody that he was involved in a relationship. An altercation ensued, he shot her, and again, the court found that there wasn't a sufficiently close enough connection in order to hold the employer liable. In the third matter, the court had a look at a matter where a lady asked for a lift home in the early hours of the morning, and she was given a lift home by the police, and they raped her.
Right.
And the court in that instance found that there was a sufficiently close enough connection, and they did hold the employer liable.
Craig, you were talking, and I kept hearing you talking about a sufficient association,
Yes.
connection between the act of the employee and the business of the employer. That makes it a bit tricky, though, because there's no connection between you raping and killing someone and what the post office does.
Right. So that's why I'm saying to you that the court will look at the facts and will say, is there a sufficiently close enough connection or nexus or link between the two? And really it goes a little bit further than that in asking that question, and that is, you're saying, well, did the employer ultimately create the opportunity or the conditions or the environment or the platform for that to have happened? It's not specifically only in the course and scope of the employment, because that would be too narrow a test.
Sure.
And then you'll say, well, listen, that's never, perpetrating crime is not the nature of our business. So there will never be any liability for an employer. So it's about, listen, was there an opportunity that was created which was opportunistically taken by the employee in perpetrating that crime?
In terms then of what the legal teams will need to put on the scale to perhaps sway this matter in the direction they want, certainly the ones representing the EFF and others, what will they need to do? How does their task in this case of vicarious liability differ from an ordinary delict matter?
Okay, so because the way the courts have moved in terms of their approach by saying, listen, was there a forum that was created? It's already setting the tone for what it is that has to be proved. So there's almost a lesser, if I can put it that way, onus on the person trying to prove the vicarious liability than in an ordinary delict, because they are applying a stricter test for the employer, because they're saying, listen, if you have placed an employee in a position of trust, you must be ensured that you are satisfied that they can actually be trusted. And it would seem that if he was, in this particular instance, if the employee was the only person in the post office at the time, he must have been in a position of trust. And therefore, they must be held accountable for having given him that authority, given him that trust, and they must be sure that they're giving that trust to a person that can carry that trust.
Is that where the element of fault would come in then, to say, you are at fault for not ensuring that the person you put in a position that should be a position of trust is actually trustworthy.
That's the wrongfulness that's the issue of wrongfulness when you're talking about a delict and you're talking about perpetrating a wrong and the liability of the employer in that instance. That's exactly what you're talking about.
All right, Craig, this is fascinating stuff to talk about. I wanted to ask you, though, before I let you go, from your experience and observing this area of the law, is there anything employers can do better to avoid being in situations such as these?
I think the key word is vigilance. I think that if employers are far more vigilant, and in this particular instance, and again based on the reports that are emerging, it seems that this information was available to the employer, that they had the opportunity to take cognizance of it and maybe perhaps act more diligently on it than what they actually did. And who knows, it might well have prevented this unfolding. But as I said, it's not necessarily only employees with criminal records who are, for those, their employers who are held liable for the actions of the employees. So it might well be that employers just need to be a little bit more circumspect and a little bit more careful when placing people in position of trust.
And I guess these issues of vetting, particularly in positions of trust, must slowly become something that we get used to, that it should happen.
Absolutely. It's because of exactly this sort of risk that the employer exposes themselves to by virtue of being vicariously liable that they should be more vigilant and mindful of who it is that they're placing where and what the possibilities are by placing them in that position.
Craig, thank you so much. I've really enjoyed your insights. That is Craig Berkowitz, who is a labor law expert, unpacking the issue of vicarious liability, which is, it looks set to really become a feature of what is likely to happen going forward in the courts in the wake of the killing of Uyinene Mrwetyana.